All right, without any further ado, Mr. Chris Pettit.
Thank you. Thank you. Appreciate you having me. This is going to be pretty informal, so if you have questions, please raise your hands. Fair housing is a really, really important topic. I always let clients know up front that the best thing to do with fair housing is to act in such a way so that you never have a fair housing complaint. Because once you're in the middle of one, they're very long, they're very lengthy, they can be a fishing expedition, they pry, they can talk to your tenants, they can, when they're investigating, and whether you did anything wrong or not, your tenants will probably think you did based on the types of questions that they're being asked. Secondly, they're very expensive. Most insurance doesn't cover these unless you have special insurance. So if you're paying money, you're paying it out, and you're also going to pay for an attorney to help you with that process. Third, they don't just name your company or just one apartment building. They name each and every person individually. So your property manager, if they interacted, if your leasing specialist was involved in the action, all of those people get named personally. That doesn't happen in lawsuits. It does happen in fair housing complaints. The reason I'm scaring you straight up front is just so you know whether or not you're going to win or lose. You're still going to lose because of the time and money involved. And the best situation is to act in such a way so that you never get one of these claims, because it's not a fun situation. Does anyone have an idea, if you tell me what the definition of fair housing is? Sir?
Treat all people the same.
Yep. That's the easiest way to think of it. Treat everyone the same. And to help you do that, there's going to be processes you're going to need to follow to make sure that you treat everyone the same. You might be having a bad day one day. You could be picking up the phone while you're doing 10 other things. And so you unintentionally might treat someone differently. The days of landlords or property managers just saying, "Oh, I'm sorry, we don't rent to people like you," those are gone, thank God. What we have instead are the claims are, "Oh, you didn't tell me about all the amenities at the apartment complex offers, but you told that person." Or, you asked me a couple of questions that I don't think you would ask other people. I had one client that she had a showing, and the prospective tenant was late for the showing, and she had a personal matter she had to go to. And rather than just slowing down and saying, "I'm sorry, you're late for the showing. I'd love to take you to the showing tomorrow. We can do this tomorrow. Here's our application. You can look this over. I'll call you tomorrow," or something like that. She goes, "I can't show this to you. I can't show this to you," and got in her car. She got a fair housing complaint just for that 30-second interaction, because the person said, "You saw that my boyfriend had a tattoo, and that tattoo was something that was protected, and so next thing you know, you're defending against it." The other thing you want to do with a lot of these is avoid he said, she said situations. Those are the worst type of situations for lawyers to deal with, because fair housing claims can be brought up to 2 years after the discriminatory act. Think about one of your interactions with one of your potential tenants or an actual tenant 2 weeks ago. Can you tell me about it? Can you tell me how you acted, what you said exactly? You're probably not going to be able to, because you interacted with so many people. But again, to that person, you're the person that's doing something wrong. They are going to remember all of it. So we have to put these processes in place to protect you from these types of situations. So in the terms of discrimination in housing, it really covers a wide range of topics. I mean, if you refuse to rent to somebody, that obviously would fall into it. If you refuse to discuss the terms of a rental with them, if you refuse to renew a lease or cause them to be evicted, if you misrepresent the availability of housing. So, "Oh no, I'm sorry, we don't have any openings here," but then they send a tester and the next day you're talking and you do have an opening all of a sudden. If you apply different terms or conditions to people, if you refuse to allow reasonable modifications or accommodations to people with disabilities, if you print, publish, or advertise anything that shows a preference. So a lot of this you don't have to have the intent for. The example I give that kind of brings everything home is, let's say you have an open unit on the second floor, open unit on the first floor, and a family comes with little toddlers. You have a porch on the second floor, and you're just concerned, those toddlers like to crawl, toddlers like to climb. What if they, climb up on the railing and cause some problems? So as a result of that, you only show them the first unit or the first floor unit, or you only tell them about the first floor unit. You are engaging in discrimination in that example because you're making a decision based on a protected class, the fact that they have children, and you are only showing them one area. So you're kind of steering them to that first floor unit. What you really need to do, and I know this is going to sound crass, but the right way to do it is to show them both the first and the second floor unit. Let the parents of the children decide where they want to be, whether it's a smart decision or not. And if they choose the second floor and the kid climbs up the railing and gets hurt, they're going to sue you. But that's the way you're supposed to handle it. You can't make that decision for those parents. So it's more than just, oh, we don't rent to people like you. It's all kind of subtle things like that. It's putting an ad out that says, this property is close to St. Michael's Church. I've seen complaints saying, you're trying to favor Catholics in this situation. You want Catholic people here, so therefore I'm Muslim, I'm Jewish, you don't want me here. So you do not need to have intent to discriminate in order to be liable for discrimination. Let's talk a little bit about this fair housing process if a claim is filed. There's two avenues that a tenant, a prospective tenant, or an actual tenant could follow. There's both a federal system and a state system. The federal system is through HUD. State system is through the Department of Workforce Development's Equal Right Division. So there could be two claims, the exact same incident, filed through the state system and the federal system. Now, in most situations, you can get the investigator from one of the agencies to take charge, and the other one will just monitor. But that doesn't always happen. I'm defending one right now. I'm defending it on two different fronts. The state has come back saying that there is probable cause for discrimination, so we have a finding out there, and the feds are telling me that they don't think there is discrimination here, so they're going to have a no finding. So there's all kinds of just procedural, bureaucratic problems that you have to deal with too because of the dual agencies. A lot of times the claimant, they can have an attorney, but sometimes they don't have an attorney. Sometimes they just have somebody, a representative from a local fair housing agency who's assisting them, who knows this process and knows what they're doing. The other thing is, those of you that might be familiar with proving up damages or actual damages, where, okay, I'm injured, here's my medical bill, here's my lost work, those are actual damages. But you're also dealing with pain and suffering, where the person can say, because of this discrimination, I went into a depression. I felt less secure about myself. I had problems concentrating. I didn't sleep as well. The stuff that's more touchy-feely, that is big in fair housing. It's happening more and more, and it's just something you have to be prepared for. So let's talk about the protected classes. Essentially what discrimination is if you make a decision that affects housing solely because the person is a member of a protected class. If you make a decision based on other reasons, like your screening criteria or your policies or the language in the lease, that's different. What I want to just put out there right up front is that A lot of people go, oh, I'm dealing with a person from a protected class. I need to be careful. All of you, all of us are members of a protected class. We all have a religion, or we don't have a religion. We all came from someplace. We have kids or we don't have kids. We're married or we're not married. All of those are protected classes. So don't think this is just limited to certain groupings of people. Every one of us is covered by this. So what are the federal protected classes? The feds have 7 of them. Race, color, national origin, religion, sex, familial status, and that's broad. Usually that's talking about do you have children or not, but it also can be are you married or not married. Handicap, disability. It still uses the word handicap, even though that's not PC anymore. So again, what I want to just point out is even if a person is a member of a protected class, and again, we are all members of a protected class, as long as you do not make the decision based on the fact that they're a member of a protected class, you're okay. So an example I have at the bottom of page 5, a landlord denies the application of a person using a wheelchair because they have no prior rental history, not because of their disability. Second example, a landlord denies the application of a person with children because she does not have sufficient income to meet the landlord's screening criteria, not because of the fact she has a bunch of kids that might be too noisy and may be disruptive. So what is the definition of a person with a handicap or a person who's disabled? Well, it's a person having a physical or mental impairment that substantially impairs one or more of their major life activities. What's a major life activity? Talking, walking, caring for themselves. It's pretty broad. It's not just the person that has that disability that meets the definition. It's also somebody who has a record of having that type of disability. So they can no longer be disabled, but in the past, if they were, they're still protected under the Federal Fair Housing Act. And it goes even further if you treat them as if they are disabled. Whether they are not, whether they're disabled or not, they are still protected under the Federal Fair Housing Act. So those are the 7 protected classes. So that's federal. But again, you have Wisconsin's open housing law too. So that has the same 7 protected classes, but they added a few more. Sex, marital status, sexual orientation, color, race, disability, religion, national origin, ancestry, lawful source of income, family status, victim of domestic violence, or age. Now when I talk about age, please understand that if you are dealing with somebody who's under the age of 18, they can't enter into a binding contract. So you can refuse to enter into a contract with a 17-year-old. That is okay. I'm talking about once you're dealing with 18-year-olds and above. You can't discriminate based on age. So now we're up to 13 that you have to remember. Now let's talk about the city of Milwaukee, because local municipalities have additional protected classes. Milwaukee has 18. Sex, race, religion, color, national origin or ancestry, age, disability, lawful source of income, marital status, sexual orientation, gender identity or expression, victimhood of domestic abuse or sexual assault, past or present membership in the military service, HIV status, domestic partnership, genetic identity, homelessness, and familial status. I kind of advise you all that you need to find out whatever municipality your property is and look at their local ordinances. And I mentioned that Dane County is one that has even more. You see how broad this is? This covers all of us. Again, everyone is a member of a protected class. And that's why what you said at the outset, treat everyone the same, is what you need to do. You don't want to be making a decision based on any of these things we just talked about. If you have screening criteria, and that screening criteria has been vetted and it's okay, and we know it's not discriminatory, that's different. You might be making a decision because they don't meet your screening criteria. Nothing is wrong with that, even if they are a member of a protected class. But the point is, you need to be able to prove that. I can tell you the first 20 or so cases I've handled like this, 19 of them didn't have written screening criteria. So what's that mean? You're saying, oh, I denied them because of this, and that's okay, that's acceptable. But they're saying, no, you're not. You denied me because of this. It's a he said, she said. Who wins? Judges hate those. They have to try to decide who's more credible. So you want to have that screening criteria so you can say, look, number 3 says you must meet this obligation, and look, I went online, or here's my background report, and it shows they don't meet this. And now you have that. Now it's not just your word. It's your word plus documentary evidence. Also want to point out Milwaukee County has added a new protected class. And this is really new. This is last summer. Basically, any person that receives a rent assistance voucher, you cannot deny them solely because they receive a rent assistance voucher. In the old days, you could advertise no Section 8. You cannot do that anymore. A lot of people who were receiving Section 8 would call you, and that was the first question. They didn't want to waste their time. They'd say, do you accept Section 8? And you could say yes or no, and that was fine. Right now, you have to say yes, we do accept that, and make them go through the process. And then you're going to have to talk to one of your supervisors, and who will stay in touch with me on how this all plays out. Let's talk about some practical applications dealing with screening criteria then. Sometimes when I give this presentation, people are like, oh my God, everybody's protected here. What kind of screening criteria can I even have? And I want you to rest assured, there's a lot. You still have control. If they don't provide complete answers on their application, you can still deny them for that. If they provide false information, deny them for that. If the information they provide cannot be verified, you can deny them for that. It's not their fault that their landlord won't call you back to do a landlord reference, but if you can't verify it, you can deny them. If their income doesn't meet whatever your standards are, things like smokers, if they smoke, smokers are not a protected class. People that have pets, and I'm not talking about emotional support animals, assistance animals, we'll get to that later, but pets are not a protected class. So just to give you an example of what that means, you could just be crazy on your screening criteria with pets. You could say, I'm only going to allow dogs that are 50 pounds or more because I don't like those little squeaky ankle biter dogs. I don't want any of those little things around. So there is room for you to still move about, okay? I just don't want you to feel too boxed in. Let's talk a little bit about criminal background. The whole point of screening criteria is to have objective basis to deny someone or approve them, okay? You don't want to have any subjectivity, because subjectivity changes from person to person. There are tons of studies out there that say we are more comfortable with people who are like us, people that look like us, pray like us, dress like us, and so therefore we're uncomfortable about people who are different. So you may be discriminating and not even be aware of it, just based on those studies, because you're not as comfortable. You need to have objective basis. You must make this much money. Okay, you get their paycheck stub. You call their supervisor. You verify that. All objective things. Problem is, HUD came out with a memo in April of 2016 and muddied the water substantially. They basically have said, you need to deal with a person's criminal background on a case-by-case basis. You shouldn't have any across-the-board blanket parameters. And then they tell us a bunch of other things that they think you should consider. But they don't tell you what you can do and what you can't. And right now, nobody knows. So that is a very difficult area right now. I give you some references on the bottom of page 4 to HUD's memo. Now, this memo is not law, but HUD is issuing it. HUD is the investigative agency at the federal level for fair housing violations. So if they're putting out a memo on what the rules are as they see it, you got to pay attention. So usually we learn things, lawyers and people that follow the law, because you have appellate court decisions and they tell you this you can do, this you can't, this you can, this you can't. Well, we don't have that in fair housing because most of them don't go that far. So essentially what we have is landlords agreeing to pay money, conciliating the complaint. It's called a conciliation agreement, where you agree to pay some money, go to fair housing training, do X, Y, and Z. And then HUD releases a press release. Landlord in Wisconsin pays $15,000 regarding emotional support animal. And then we go and we read that conciliation agreement and learn the facts. And now I file that in my research files. And when you guys call me, if the facts are similar to that, now I can tell you, well, just so you know, another landlord settled that for about 15 grand, so we need to be careful. That's all we're going on. We're waiting for each press release to learn a little bit more and a little bit more. There are some things we have learned. You cannot just have a blanket ban that if you've ever been convicted of a felony ever, you'll be denied. They mention studies where they say that the percentage of recidivism of engaging in a new crime after 6 or 7 years is about the same as a person that's never committed a crime committing a crime. So what they're saying is they want your look-back period to only be 6 or 7 years. So that's going to be something tricky in terms of your screening criteria. What I tell my clients to do, easiest thing, we don't know the answer to that. Do that last. Don't even don't ask for that criminal report until you've checked everything else. Because maybe you end up denying that person based on the landlord reference, or they don't make enough income. You don't even have to get to the criminal background issue. So I kind of say, set it up in 2 stages. Stage 1, everything else. If they don't pass stage 1, you don't have to get to stage 2 about the criminal background. You don't have to worry about that. Yes?
I know if someone's been charged, that's not a conviction, so they're innocent until they're proven guilty. What happens if they're in deferred prosecution? How should we handle that?
According to HUD, that's not a conviction. Okay. So you can't consider it. You can't consider arrests. You can't consider pending cases. This is what's troublesome. So you have somebody has a pending case for dealing methamphetamine, and the trial is in 2 months. What are you going to do? Again, we don't know. So you have 2 separate issues there according to HUD. And again, this is according to HUD, not the law, but 2 separate things. One is you are innocent until you're guilty, and there's tons of people that have been arrested and charged with crimes that shouldn't have been, and so you can't consider that, period. Then let's look at the crime if there has been a conviction and analyze exposure to safety and things like that. So you're still at the first level here, and the deferred prosecution agreement is not a conviction, so you don't get to that second prong yet. So that's the way you'd need to analyze it, unfortunately. Yes, ma'am?
Is there anything on fair housing concerning occupancy standards?
Occupancy standards are important because oftentimes people will call you up on the phone. Will you rent to me? I want that 2-bedroom. It's me and my 5 kids. And they don't want to apply unless they know you will consider them, because they're wasting time and wasting, an application fee and all that. And guess what? You don't want to answer that question. You invite them to apply and say, we'll evaluate things at that point. Because what's going to happen again is that's very unclear. So what I tell my clients to do is you process that application. If they don't meet your screening criteria, you never have to answer that question. If they do meet your screening criteria, then you call me up and we will analyze it, and I need a schematic of that unit, knowing all the dimensions of all the rooms. I have to see the layout, and then we're going to check any ordinances, like Milwaukee has an ordinance dealing with that, other areas don't, and we're going to have to evaluate it on a case-by-case basis. You can start with 2 persons per bedroom, but then you have to factor in 7 different options, 7 different factors that either might increase or decrease it. Because I have a lot of clients, at least I did, that came right out and said 2 persons per bedroom, 2 persons per bedroom. I attached link after link of all these lawsuits of landlords getting sued for 2 persons per bedroom, 2 persons per bedroom. Yes, sir.
Generally, we ask people how many occupants would be in the apartment, so does that mean we can't ask that question?
What is the purpose for you asking that question? Is it to make this decision, or is it for another reason? I'm not putting you on the spot. If it's for this decision, I probably would recommend you don't ask that question, because any calculation you do on that, as I've just explained for the last 10 minutes, is going to be suspect. If you have another reason you're asking that question,
To make sure that they're all listed on the lease.
okay, that's fine. You can. How many people will be living here, and you want to make sure they're on lease? I see no problem with that, as long as you maybe clarify that for them, because you let them know we're not going to allow any, we're not. Everybody's going to be listed on this lease. No one's just an occupant and doesn't sign. We need to know that so we can get this ready for you. I don't see a problem with that. All right, now let's move on to people with disabilities. This section is solely based on people with disabilities, but this is a huge group. The largest percentage of fair housing complaints that have been filed for the last several years are people who are disabled. We have a lot of returning war veterans that have disabilities. We also, the stigma of mental health issues has kind of gone away a little bit. People will admit that. More people are being diagnosed with it. And so this isn't going away. People with disabilities is probably still going to be the largest area of complaints in fair housing. So let's talk about that, because they have some specific laws that apply to them. What I want to tell you is we're going to talk about reasonable modifications and reasonable accommodations. You are probably always going to deal with accommodations as opposed to modifications. What I want you to pay attention for, though, is the analysis is exactly the same. Modifications essentially is a person with a disability is coming to you and saying, I need you to make a physical modification to my unit or the building, some physical structure, because I have a disability and I can't enjoy housing the way a non-disabled person can without this modification. Modification is a physical change, okay, that they can request. Could be a common area, could be an inside their unit, could be an outside their unit. There's a couple things that there has to be. One, they have to have a disability. Oftentimes, when it's a modification, it's a physical disability. They're having trouble walking or something like that. There then has to also be a relationship. They call it a nexus between the disability and the reasonable modification request. So for instance, if a person is in a wheelchair and they come to you and say, I need to have a ramp put in the front so I can access the building, because maybe it's an older building that's not compliant, you can see they have a disability, you see the connection, it's done. You don't need to inquire anymore. In fact, you're not allowed to. If for some reason the disability is not apparent or obvious, or the connection is not apparent or obvious, then you have the right to ask for more questions. If there is not an identifiable relationship between the disability and the modification, you can deny it. The tenant is going to be responsible for any upkeep and maintenance of that modification if it's in their unit or solely within their control. If it's in a common area or outside, then you're responsible for it. They can make this request orally. They have to make the request. They can't just assume you know this is what they want and go and start doing things. So again, let's just think about the wheelchair ramp. They can't just go and call somebody up and start installing that. They need to ask you, at least. I suggest the best policy is, again, get all of this in writing. So you want to have a policy in place, have a form that you use to make sure you're asking the same questions of everybody, have a verification form to send off to a healthcare provider to verify everything and treat everyone the same. You have to give your approval before they make the modification. And then there's a lot of other questions out there on what's allowed, what's not. Remember, this is a reasonable modification. Reasonable is the key word. What is reasonable is different to different people on different days. So it's a little bit of a case-by-case basis. Again, I want to give you some other examples of reasonable modifications. We talked about the ramp, putting railing in the bathroom and the shower area for a person that's mobility impaired, maybe lowering the light switches and the countertops for a person who's wheelchair bound. That's another example of a reasonable modification. Maybe you have a policy that says you cannot have anything on your doors, and you have a policy that says you can't modify anything and make holes and things like that, but you have a person who has a hearing disability and they want to install a peephole. That would be another example of a reasonable modification. And so that's important to know, because if this comes up, if you were to increase their security deposit, that would be a violation of fair housing, because you're increasing a security deposit based on the fact that they're disabled, which is a protected class. But there's a statute that says you can enter into a restoration agreement whereby they must put the money into this account. So again, this is one of those things, it's form over substance. You got to do it the right way and you're okay. You do it the wrong way and you're violating fair housing. Now let's move to the thing everyone wants to talk about, reasonable accommodations. The reason everyone wants to talk about this is when we're dealing with emotional support animals in that whole area. It is broader than just emotional support animals, okay? The analysis is the reasonable accommodation process, and what that is someone has the right, if they are disabled, to ask you to accommodate them by changing your policies, your procedures, your rules, because they need that change in order to enjoy housing the way a non-disabled person would be. That's the thought process. This can happen at any stage of the process, rental process. So even applicants coming to you could make a reasonable accommodation request. Let's say your policy is to do everything online, the application's online, and you have somebody who has a disability and says, I'm unable to access that online because of my disability, I want a hard copy. That would be a reasonable accommodation request that you'd have to accommodate. You have somebody who's come in who's blind. Let's say you have a printed application, but they say, I want this translated into Braille. Unless you can come up with another suggestion or another workaround that both parties are agreeable to, you would have to make that accommodation because they're blind, the connection is there, they're disabled, and the connection is open and obvious. Let's say you have no assigned parking. You just won't assign it. But then you have somebody who's mobility impaired and says, look, I need you to change this policy and give me an assigned spot closest to the entrance. That would be another reasonable accommodation request. So let's just talk about a few other examples of reasonable accommodations. So obviously, you have a no pet policy. You have somebody that's blind. They have a service animal that's trained to help guide them. That's a reasonable accommodation request because you have a no pet policy. This is not a pet, it's a service animal. Therefore, they're asking you to allow them to do that. That would be a reasonable accommodation. If you are ever truly dealing with a service animal, you are fine. Service animals are trained better than we are. They are behaved better than we are. You will never have a problem with the service animal. The issue you run into is emotional support animals because they are not trained. That could be a scrawny cat you found out in the alley, an hour ago. And now you say, I need this animal to be prescribed to help me with whatever my disability is. But what I want to tell you is a lot of people come to me with questions that if they would just swap out the word emotional support animal with another assistive device, the question would be a lot easier. So these are assistive devices just like a wheelchair, medication, crutches, oxygen. So if you're not sure, I had a client came with a very good question. He said, look, I have 4 buildings. This building I allow pets in. I just got an application from somebody who has an ESA. Is it okay for me to make them live in this 4th building? It sounds reasonable. Well, there's other pets there. Sounds like that might be okay. I said, let's change the language. You have a person with another disability, with another assistive device. They have a wheelchair. Do you think it would be okay to make all the wheelchair-bound people live in the 4th building? Swap those words, and a lot of the complicated questions for ESAs will become a little bit more simple. You can't charge a pet fee. They're not pets. You can't charge a pet application. You can't charge a pet deposit for them. You can have an assistance animal agreement. You can hold that tenant responsible for the actions of their ESA. And as I said, a lot of them, since they're not trained, cause a lot of problems. You can evict people for the actions of their ESA. I've evicted lots of people because their dog goes and mauled another dog or bit somebody or barks through the night. So you can do that. You can still fine them if they don't pick up the poop of their ESA. So everything is the same in terms you can have guidelines for them. It's just remember they're not pets and you can't charge fees and you can't charge extra deposits and things like that. But your hands aren't as tied as much as they will let you think they are. Okay? Thank you very much. I appreciate it.
Thank you.